Can ships be arrested? Well, this sounds unusual, but it is very much possible in marine jurisdiction. Hello and welcome to Drishti IAS. My name is Saloni Nankyolier, and today we will talk about the Admiralty Suit, which is responsible for dealing with all forms of marine disputes. So very recently, the Kerala High Court ordered the conditional arrest of a Liberian ship, MSC Aita 2. It was anchored at the Visakhapatnam port in Kerala, and this ship caused the sinking of another Liberian ship, which was MSC Aita 3, and it was carrying over 600 containers of hazardous materials like plastic pellets and diesel. Now imagine the amount of marine pollution and environmental damage this sinking would have caused. And even though both these ships, they were Liberian, but the damage happened over Indian waters. That is the reason that Indian maritime jurisdiction comes into picture, and the Kerala government filed an Admiralty Suit, which was heard by the Kerala High Court, and the court ordered the arrest of this ship. And what do we mean by the arrest of a ship? It simply means that the ship is now under custody and its movements are restricted as per the court's order until the claims are settled. So this is about the news that has happened. Now let us see what is Admiralty Suit. So Admiralty Suit is a legal proceeding or a lawsuit which deals with all forms of marine disputes. All forms of disputes which require compensation over economic or environmental damages which have happened at the sea are taken care of by an Admiralty Suit. For example, marine pollution, contracts, or any injuries that occur at sea. And which Admiralty Act is active in India right now? It is the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017. Now this is not the first act in India. Before this also there were some colonial era acts which were the Admiralty Court Act of 1861 and the Colonial Courts of Admiralty Act 1890. So both these colonial acts, they had given the jurisdiction for marine disputes only to three presidencies of British India, which were Bombay, Calcutta and Madras. But with the new act, the jurisdiction has been expanded to courts in Kerala, Karnataka, Odisha, Telangana and Andhra Pradesh. So more coastal states have been included, more high courts have been given jurisdiction over the marine disputes under this new act. And if we talk about the specific legal provisions, it is Section 4 of the Admiralty Act 2017, which allows the courts to hear claims related to damage caused by a vessel to an environment, compensation for such damage, and the cleanup and remediation measures. So this particular section of the Act has been invoked in the current scenario, and the claims are being settled under this section. In fact, additionally, there are more laws that deal with marine jurisdiction, which are the Merchant Shipping Act of 1958, which makes the ship owners liable for any form of oil pollution, oil spill that happens in the sea. Then the Environment Protection Act of 1986 also enables the authorities to act against polluters, because marine pollution is also a form of environmental pollution. So Environment Protection Act 1986 also gives some powers to the authorities. Then the National Green Tribunal can also award environmental compensation. NGT also has some powers. In fact, in 2016, when there was an oil spill from a Panama-linked ship, it was fined rupees 100 crore. NGT had fined 100 crore to that ship. So NGT also has powers, Environment Protection Act also has powers, Merchant Shipping Act 1958 also has powers, and the Admiralty Act of 2017 of course has powers. Now, if we look at the need for having such strong regulations and what is the way forward, so we need to understand that with the growing emphasis on blue economy, in fact, India also has a Sagarmala initiative where we are focusing on port modernization. We need to ensure that our climate is not affected, our environment is not affected, and any polluter is held accountable for. So that is the reason that we need to have stronger maritime regulation and monitoring mechanisms. In fact, this may also set a precedent, because we already mentioned that these were both Liberian ships, these were foreign ships, but the infliction happened at Indian borders, in Indian jurisdiction. So they cannot simply walk away from the damage that they did. They will be held accountable for what they did in the Indian territory. So this will set a precedent for holding foreign shipping companies liable for marine pollution in Indian waters, which is very, very important. Then the role of state governments in using admiralty laws to seek justice and environmental compensation has also come into picture here, because we saw that the Kerala government filed an Admiralty suit. The Kerala High Court listened to it. So the states like this, they need to be proactive. The coastal states need to be proactive, and they need to keep on taking such measures for anything that happened in their territorial waters. So that was all for today's video. I hope you understood what Admiralty suit is all about. Now let us look at a practice question for prelims. With reference to the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017, consider the following statements. 1. It replaced the Admiralty Court Act 1861 and the Colonial Courts of Admiralty Act 1890. 2. Only the High Courts of Bombay, Calcutta and Madras have jurisdiction under this Act. 3. Environmental damage caused by a vessel can be claimed under this Act. Which of the statements is or are correct? A. 1 and 2 only. B. 1 and 3 only. C. 3 only. Or D. 2 only. Please provide your answers in the comments section, and until we meet the next time, please keep studying and keep revising.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.